Welcome back to G-Man-P, the Great TV. If you tuned in, hit a like, share, and subscribe. If not, we ain't doing no tripping. Now, today, we're getting into the fat and the meat. Like, we bringing it back to Ohio. You understand? And it's going to show that these next couple different things that I'm going to be doing, it's going to show that everything I was saying is pretty much true. Like, that there's like, what I mean to say is, like, there's people it's a trait that they're doing. They keep doing the same thing, and but today what we're gonna be talking about is a bribery scheme. It was called the red light camera contract in Columbus, well, in Ohio, period. It's about the red light bribery scheme. So everything that I'm saying ain't no lie. You understand? Former CEO sentenced for bribery fraud scheme involving red light camera contracts. Columbus, Ohio. A former CEO of a traffic light enforcement camera vendor was sentenced today to 14 months in prison for her role in a multi-year bribery and fraud scheme, announced Assistant Attorney General Leslie R. Caldwell of the Department of Justice Criminal Division, U.S. Attorney Benjamin C. Glassman of Southern District of Ohio, and Special Agent in Charge Angela L. Byers of the FBI Cincinnati Field Office. Karen L. Finley, 57, of Cave Creek, Arizona, was sentenced today before U.S. District Judge Michael H. Watson of the Southern District of Ohio. She pleaded guilty on June 19, 2015. to one count of conspiracy to commit federal programs, bribery, and honest service wire and mail fraud. Finley cooperated with the government's investigation against John Raphael, an Ohio lobbyist, who pleaded guilty to one count of violating the Hobbies Act for his involvement in the scheme. On June 8, 2016, Raphael was sentenced to serve 15 months in prison. From December 2005 to February 2013, Finley served as CEO of the Red Light Camera Enforcement Company. During this time, she participated in a scheme in which the company made campaign contributions to elected public officials in the city of Columbus, Ohio, and Cincinnati through Raphael, a consultant retained by the company. Finley and others, including another executive of the company, agreed to provide the conduit campaign contributions through Raphael, with the understanding that the elected public official would assist the company in obtaining or retaining municipal contracts, including a red light camera enforcement contract with the city of Columbus. Finley also admitted that she and her co-conspirators concealed the true nature and source of the payments by Raphael and the company's payments of the false invoices for consulting services, which funds Raphael then provided to the campaign of the elected public officials. The FBI Cincinnati Field Office, Columbus Resident Agency, investigated the case with the assistance of the IRS Criminal Investigation and Ohio Bureau of Criminal Investigation. Trial attorney Edward P. Sullivan of the Criminal Division Public Integrity Section and Assistant U.S. Attorney J. Michael Morris of the Southern District of Ohio prosecuted the case. So that was just the story in Columbus, Ohio, how they used this scheme at red light. They had these cameras at the red light. You understand? And you might not even turn. Like one time I had got it. They hit me. I ain't never got my money back. But one time that I didn't even, you get kind of close to the white bar, it snaps a picture like you made a, like you wasn't supposed to make right hand turns anymore. You understand? And it was just like the scheme, that it was a big scheme that these people that these officials. So I know my story ain't no lie, because it's going to be, I'm going to show you that they all keep, it's like these individuals, they keep doing, people get prosecuted and they have these same corrupt practices that they're doing. So whatever I'm talking about ain't no lie. Now we're going to talk about the restrictions of the red light cameras, rules, and how it was unconstitutional. Three of the many provisions of the 2015 state law regulation of the use of red light and speed cameras are unconstitutional because they infringe upon municipal authority without serving and overriding state interest. The Ohio Supreme Court ruled today. In a 5-2 judgment, the court agreed with the city of Dayton constitutional challenge to parts of Senate Bill 342, which took effect more than 2 years ago. In the lead opinion written by Justice Patrick F. Fisher, the court found the regulations were not general laws that applied evenly throughout the state, but instead were regulations that improperly limit legislative powers of a municipal corporation to set police, sanitary, or similar regulations. Justice Fisher's opinion was joined by Chief Justice Maureen O'Connor and 5th District Court Appeals Judge Craig R. Baldwin. Setting on assignment for Justice Terrence O. O'Donnell, Justice Judith L. French wrote a concurring opinion, also finding the law unconstitutional, but on different grounds, that Justice Fisher, Justice Sharon L. Kennedy joined Justice French in ruling the challenged laws violate the Ohio Constitution's Home Rule Amendment because they fail to prescribe a rule of conduct among citizens generally. In March 2015, laws adopted by the General Assembly took effect. Regularly, local authorities used of automatic traffic enforcement programs, citing the Home Rule Amendment. Dayton and other cities asked the court to strike down some requirements in the new law, including a rule that a police officer be present at the location of each traffic camera. Both Justice Fisher and French cited the Supreme Court 2002 Canton v. State opinion, where the court developed a 4-pronged test to determine whether a law violates home rule. The court reinstated the trial court's permanent injunction preventing the provisions from taking effect. In separate dissenting opinions, Justice R. Patrick DeWine and William M. O'Neill questioned the validity of the Canton test, and Justice DeWine argued the court has so inconsistently applied Canton that it does not Dayton objective to restriction. Dayton did not challenge all of SB 342, but only 3 sections that is believed did not qualify as general laws under Article Section 3 of the Ohio Constitution, which grants home rule powers. Dayton filed a lawsuit in Montgomery County Common Pleas Court challenging RC 4511.093B1, which requires a law enforcement officer to be present. RC 4511.09112, which prohibits a fine to a driver caught speeding by a traffic camera unless the driver exceeded the speed limit by 6 miles per hour or more in the school or park zone, or by 10 miles per hour in other areas, and RC 4511.095, which directs a municipality to perform a safety study and conduct a public information campaign prior to using a camera. In 2002, Dayton permitted its police department to use traffic cameras to civilly enforce red light violations with the intent to conserve police resources and reduce traffic violations and accidents. Prior to the installation of the camera, the city conducted studies to identify intersections with high numbers of traffic accidents. The introduction of the cameras led to a decrease in violation-related accidents, and in 2010, Dayton amended city law to use traffic cameras to reduce speed violations. The fourth police sanitary or similar regulations ran through purpose only to grant or limit legislation powers of a municipal corporation to set forth police sanitary or similar regulations. 4. Prescribe the rule of conduct upon citizens generally. In the lead opinion, Justice Fisher wrote that the contest provision failed the third prong of the test and are unconstitutional. Justice Fisher noted that while he and 2 others struck down the law based on the third prong, the laws also may be unconstitutional under the 4th prong, as asserted by Justice French. Justice Fisher cited a 1982 Ohio Supreme Court decision, Claremont Environmental Reclamation Co. versus Welderhold, and state that a statute which prohibits the exercise by a municipality of its home rule powers without such statute serve an overriding statewide interest would directly contravene the constitutional grant of municipal power. He noted that under the court's precedent, as long as the state law serves an override state interest regard police, sanitary and similar regulations, the third prong of the Canton test is met even if it limits the authority of municipality. So pretty much right there, they're just explaining how, you know what I'm saying, like they did like a test, and after they ran the test, this is one of the Supreme Court Justice of Ohio, and was just stating that how it's unconstitutional after they ran this test with these prongs. Officer presented provision examined when reversing the trial court. The 2nd District agreed with the state that the entire law of all of SB 342 must be examined to determine if there is an overriding state interest. The Supreme Court, however, agreed with the trial court that the provisions can be examined individually. RC 4511-093B1 states that local authorities shall use a traffic law photomonitor device to detect and enforce traffic law violations only if a law enforcement officer is presented at the location of the device at all times during the operation of the device. The state contended the law has an overriding state interest because it represents a compromise by not taking place an outright ban on traffic cameras, but establishing them as secondary enforcement tools so the officers do not have to stop every violator. The court ruled the officers present at traffic camera contradicts the purpose of the traffic camera. which is to conserve police resources, and it is not, the law does not require the officers to witness the violation. That means the camera is the primary enforcement tool, not the secondary tool, the option stated. So pretty much there, they just came to conclusions that that they shouldn't be working this red light camera without a police presence, because I guess it took your speed, and it took pictures of you to give you a ticket. So they just concluded like they kind of snuck it in on the general public, and they should have went about it in a orderly fashion instead of trying to sneak it. And they're just saying for them to citate anybody, that police would have to be on the side of that road right where that camera's at all times. If not, that's what made it unconstitutional. Speed leeway provision acts as increase in speed limit. RC 4511-912 prohibits a ticket that relies on a traffic camera unless the driver was caught in excess of 6 miles per hour or more in a school or park zone, or 10 miles per hour elsewhere. The court stated this dictates how municipalities must enforce speed limits within their territories, thus limiting their legislative power. The state argued the overriding interest is that the law accounts for errors in a driver's speedometer or a traffic camera's measuring device. The lead opinion stated that argument contradicts the contention that the camera are second to an officer's observation of speed. It also operates as a de facto increase in speed limits in the limit areas covered by a traffic camera, the court noted. So pretty much they just came to a conclusion that it was illegal and how they went about it, and without a police being there, nobody could be cited a ticket. You understand? So we was just talking about today about the bribery and fraud scheme involving red light camera contract with the locals of Columbus, Ohio, and they had a lobbyist interchanging the money. So to everybody that was tuned in to G-Man P, we ain't doing no tripping. And to the ones that was, I appreciate it. Peace.